Okay, good afternoon, everybody. Joining me today are Mr. Kenneth Beggs, President of the Law Society of Newfoundland and Labrador, and Colleen Janes, Deputy Minister, Department of Municipal and Intergovernmental Affairs. Last October, as part of Premier Davis' announcement of the restructuring of some departments, the Lands Branch, including the Division of Crown Lands Administration, moved from the Department of Environment and Conservation to the Department of Municipal and Intergovernmental Affairs. The purpose of bringing the Lands Branch to the Department of Municipal and Intergovernmental Affairs was to create an opportunity to streamline processes and create a more efficient system for everyone's benefit. Crown Lands processes intersect regularly with the Land Use Planning section of the Department of Municipal and Intergovernmental Affairs and with municipalities. By bringing the Lands Branch under this department, there were some processes that could be streamlined, which we are already exploring actively today. For example, individuals had to present a form to municipalities if they are looking for Crown lands in a municipality to ensure it aligns with municipal zoning. Our department has all municipal town plans on file, which staff look at when assessing the application. This duplication of effort certainly may not be needed. However, it was also recognized that more changes were required and a comprehensive analysis of Crown land systems was needed. The Lands Branch is a significant point of service delivery for the people of Newfoundland and Labrador. They provide a broad scope of services from allocating Crown lands for personal and commercial use to investigating unauthorized occupation and investigation land claims against the Crown, commonly referred to as squatters' rights, and the demand for these services is significant. Last year, the branch responded to over 100,000 inquiries and received 3,591 applications. Of the 3,591 applications received, 3,083 were new applications for Crown lands, 238 were requests to amend existing Crown land titles, and 270 were for renewal of the expired term of existing Crown land titles. In 2013-2014, the number of Crown titles issued was 2,105. In responding to these inquiries and delivering their services, the Lands Branch is guided by the Lands Act and its associated policies and the business delivery model. The Lands Act dates back to 1991, with some elements dating back even further. And while it has been amended over the years, the Act has not been subject to a comprehensive review in some time. Along with recognizing the need to modernize this legislation, government also recognizes the ongoing concerns and challenges and views of stakeholders. The people of Newfoundland and Labrador, the legal community, and developers have all expressed concern regarding the need for simplified, efficient, and timelier processes and services. Since October, we've been examining some aspects of the business process, but more work is needed. Common complaints include the timeliness of application process, as well as the various steps required that can add delays, as well as cost for the applicants in some cases. For example, to build a wharf on a Crown land shoreline reservation requires advertising in papers and the Newfoundland and Labrador Gazette, and a 60-day wait before an application can be accepted. Once processed, that application based on the legislation can only be approved by the Lieutenant Governor and Council, even if there were no objections. In response to these concerns and views, today I am pleased to announce a formal review of the Lands Act and service delivery model. This review will go beyond the review of the legislation. It will also include a review of the business process for the acquisition of Crown lands, existing policies that are either dictated by or are in addition to the legislation, as well as an exploration of whether technology is being used to maximize efficiencies. It is our goal that a full review will allow us to ensure the Act reflects our current environment, is informed by best practices in place across the country, and is fair and balanced in achieving its multiple objectives. It is important to ensure the Act is clear and understandable for key stakeholders and the people of Newfoundland and Labrador, that our business processes are efficient, and that we are leveraging modern technology and service practice to best meet the needs of all stakeholders. The Lands Act has much relevance to the people of Newfoundland and Labrador, as well as a broad range of stakeholders, including municipalities, the legal community, and developers. Given the significant economic activity taking place in our province and the desire to drive further economic growth, there is a keen interest in Crown lands. While we must continue to pursue economic development, we must be cognizant that the Crown land is a valuable resource, and we have a responsibility to ensure that it is used in a manner that provides the best value and quality of life for the people of our province. It is important that we consult with everyone impacted by the legislation to improve the overall process. To facilitate this collaborative effort, a review committee will lead a consultation process across the province, including dialogue with municipalities, the legal profession, developers, as well as residents of Newfoundland and Labrador. With these priorities and main review aspects in mind, the Review Committee is comprised of 3 individuals with considerable experience, knowledge and education in the areas of law, policy, and business process efficiencies. An advisory committee also has been established and will work collaboratively with the Review Committee. The advisory committee, with representatives from the Law Society, will advise on various aspects of the review. I'm certainly pleased to have Mr. Baggs from the Law Society of Newfoundland and Labrador with me today. Collaborating with the Law Society of Newfoundland and Labrador as part of this review will prove to be a great asset based on the expertise they have in legal proceedings regarding the sale and purchase of land. I'd certainly like to invite Mr. Baggs from the Law Society now to certainly say a few words. Mr. Baggs.
Thank you, Minister Hutchings. Appreciate your invitation to participate in this announcement today. Announcement for a review of the Lands Act. The Law Society is extremely pleased to play an advisory role in this review process. Solicitors in private practice are key stakeholders when it comes to the purchase and sale of land, and in particular the investigation of Title II and ownership of land in the province. Including those with day-to-day knowledge of current practices and processes will help to ensure that this review will capture the insights of those most familiar with this legislation and its application. It's my understanding that the Lands Act was proclaimed in 1992, as Minister Hutchings indicated. That's some 23 years ago. With the passage of time, I would suggest that challenges have arisen with respect to the application and administration of the Act. The Real Estate Bar and the Law Society welcome this comprehensive review commissioned by the Department of Municipal and Intergovernmental Affairs. I wish to highlight only one of the challenges that have arisen in recent years with respect to the application of the Act, and that is, I don't want to be too technical, but it's Section 36 of the Lands Act. This section of the Act accomplished 2 things when it came into being in 1992. First, it abolished adverse possession as against the Crown, subject to certain exceptions. Secondly, it stipulated that the period necessary to claim adverse possession against the Crown is 20 years immediately prior to 1977. Thus, after 1977, there's no such thing as squatters' rights or adverse possession against the Crown. One cannot simply go out and occupy a piece of vacant land and after 1977 and hope that they can claim it by adverse possession. As well, if a person is in possession of land prior to January 1st, 1997, they must be in possession for 20 continuous years immediately prior to January 1st, 1977. So simply put, I mean, you have to show continuous possession from 1957 to 1977, 20 years continuous possession. This has been confirmed by our Court of Appeal in a 2013 decision, Ring versus Her Majesty in right of Newfoundland and Labrador. The application of this particular section of the Lands Act has created significant challenges for some landowners seeking to sell or mortgage or otherwise deal with their land, and for the Real Estate Bar in assisting them in these transactions. The availability of persons to sign affidavits of long-time possession to attest to the occupation and possession of land has become limited as the population ages and people are more mobile. People just don't live in the same community their lives as they once might have done. This has resulted in some instances of people being unable to produce adequate evidence that they have been in an open, notorious, and exclusive possession of their property for a period of time sufficient enough to defeat the interests of the Crown. It is our hope that this review will produce recommendations for the Minister and for Government to address this situation, as well as other challenges currently arising out of the administration of the Lands Act. And I must add that the Law Society has nominated a senior practitioner from our Real Estate Bar and has provided that nomination to Government, which we hope will be favorably considered for the Advisory Committee. Thank you, Minister.
Thank you. Thank you, Mr. Baggs. We certainly look forward to working with your organization as we move forward.
Thank you.
This entire review process is a collaborative effort, and we are committed to keeping all stakeholders, certainly, and the people of Newfoundland and Labrador informed every step of the way. The terms of reference to guide the review process is being developed in collaboration with the Advisory Committee. When finalized, the terms of reference will be made available to the public through the Department's website. The Review Committee will develop multiple methods of engagement to gather feedback. Opportunities to take part in the consultation process will be posted on the Department's website as well, and consultations are expected to begin in March. A What We Heard document will be released when the consultations conclude, outlining the feedback gathered. The Department will then review the document and wait for a final report from the Review Committee, culminating in certainly I, as Minister, taking recommendations to Cabinet and to Government. In conclusion, I certainly want to thank you for joining us today. The Provincial Government is committed to its focus on listening and collaborating, and certainly being innovative, and today's announcement assists in furthering that commitment. Thank you very much.